Okay, we are just at 3 o'clock, and I'd like to welcome everybody. I know that there'll be other people joining us as we have quite a few people that have decided that they would like to learn more about our series today. So this is the sixth in a series of COVID-19, tough decisions for business owners, and today's focus is COVID-19 in the workplace, understanding your legal rights. In this webinar, I'm joined by Stuart Rudner, employment lawyer and mediator and founder of Rudner Law. Welcome, Stuart.
Thanks, Hilda. I'm really excited to be here.
Good. I'll give people an outline of what we're going to do today, and then I'll ask you to give a formal introduction of yourself. So we founded COVID-19 Tough Decisions for Business Owners because we felt a need. There's so much information. And as you heard Stuart and I talking, it changes daily. Today, we just got news that the 75% subsidies has evolved one more time. And now instead of you needing to prove 30% of your revenue decrease, it's only 15, at least for March, and a few other host of changes and comparisons. So it's constantly evolving. So my team and I decided that we would offer bi-weekly webinars to people to learn about the various aspects from that human resources, from that workforce point of view. I'm going to ask each of us to give a little bio, and then our format for today will be a dialogue format where Stuart and I are going to share our expertise. Mine is human resources from a people perspective, and Stuart's human resources is from the legal perspective. And we both decided, since we know each other both, from a business perspective and have heard each other talked and even co-talked, that we thought we would like to have this kind of dialogue format. So we will talk about some key concerns regarding the options you have for employees and us as employers, the safety aspect, and then what does the future hold when employees are returning back to some sense of normality. That'll be 30 minutes, and then the last 15 minutes will be open for a Q&A where you can either email or text on the chat box. You can do it anonymously to privately send one to Jenny Ho there, or you can do it to everyone and everyone can see it. The other thing is, if you have a question, you want to have a dialogue, we invite you to mention that on the chat. We will open up allow you to speak to us then. So that will be 15 minutes, and then we'll do a final wrap up. So welcome to our session today. I would start by asking Stuart as my guest to share a little bit about himself, and then I'll share a little bit about myself.
Great, thanks, Hilda. And I won't take up too much of our time, but so as you mentioned, I focus on HR law. I've got my firm is Rudner Law, and all we do is practice in the area of employment law. We work with both employers and employees, so we see both sides. And usually when I'm asked what we do, I say we do pretty much everything and anything in the employment law world. And I mentioned things like wrongful dismissals and human rights claims and accommodation and hiring. And I usually say that what we really enjoy doing is the more proactive strategic work, the contracts, the policies, procedures, which can help people avoid liability. And what I often say is our biggest frustration is that there are so many myths and misconceptions and assumptions out there about how employment law works. And at the best of times, people are making decisions without really understanding the legal implications. And that has been magnified 1,000-fold over the last 3 weeks in the world of COVID-19, where we see people who are making decisions without understanding their legal rights, their legal obligations, what their options might be. And in many cases, making decisions, often for cost-cutting purposes, that expose themselves to liability far greater than the savings they've actually achieved. And layoffs is a perfect example. I know we're going to talk about layoffs, so I'll save that for now. But our biggest concern is that people are making these decisions without understanding the legal implications. And our goal, and the reason why we do things like this, in the last few weeks, I've done more webinars than I think I've done in my life. I've done Q&A sessions, I've done webinars. We have a running blog on our website, and I'll probably mentioned this a few times, but if you go to rudnerlaw.ca and go to the blog, you'll see we have a running blog where every time something of interest, or not interest, but of note, where it's COVID-19 workplace related, we're trying to post it. So we've got our running blog, we've got our social media. We're really trying to get the word out there because we want people to make informed decisions. You know, and you might make the same decision, but I want you to do it knowing the risks. And ideally, you're going to get the proper advice. And I'll say this now, although I'm sure it sounds self-serving. We're going to have, hopefully, I'm sure it'll be a great dialogue, but it doesn't replace legal advice. It should hopefully trigger some knowledge of issues you should be aware of, but ultimately everybody's got to assess their own individual situation. So I really encourage people to at least reach out to either our firm or another employment law firm and get the advice they need, or at least see if they need advice. And then also work with someone like you, Hilda, because you can provide, you know, a very different perspective, which is why I think this conversation is going to be great, because we can come out of
that
different
dialogue.
perspectives.
Yes, yes.
Yeah, so that's a little bit about me. And again, Hilda, thanks for inviting me to be part of it. I love the fact that you're doing this twice a week. It's great.
Yeah, we're getting into a rhythm, but the first couple of weeks was like, next, get ready. So my name is Hilda Gann. I'm the founder of People Bright Consulting, and we are a full service HR firm. So we look at all those aspects that people look at when they're dealing with people. And again, similar to Stuart, it's about policies and procedures. It's about retaining staff and recruiting them, and planning ahead. So similar to Stuart, we do strategic human resources as well as the day-to-day stuff. And what we're trying to do is, again, make sure you make the right decisions, because there's a balance between the risk legally and the long-term happiness of your company with your people. So that's balancing. And so it'll be an interesting discussion as Stuart and I are very similar, but sometimes we have a different point of view. My husband and I started our own engineering company before I started People Bright, and we were one of the best workplaces in Canada, top 10 twice. We grew to 125 people, 7 offices across Canada. So what I bring is a wealth of knowledge of running a business that grows from 2 people to 125 and creating a successful workplace. So I know it can be done, and to plan ahead and to do it so that you're balancing risk and people and work culture. My areas of focus are healthcare, engineering, IT, and the human resources side. So there's a lot of different topics that can be discussed, but I think Stuart and I want to focus on a few that we feel will resonate with you, and then we'll open it up for questions shortly. So let's start first, Stuart, with the layoffs of employees. And what kind of concerns would you like to share for the business owners with regards to laying off?
Yeah, and this is a huge topic, and I've been very vocal and very publicly vocal. I've been in the media several times over the last few weeks, and the message I've been saying is very simple. Despite the common perception, most businesses don't have the right to impose a layoff on their employees. And I know this shocks a lot of people, and we hear in the news about these massive layoffs in Air Canada and Cineplex and others. And if you go to the employment standards legislation, you'll see all the rules about how you implement a layoff. So it shocks people when I say, but you don't actually have the right to do it. And it's important to understand that the legislation sets out how you can do it. It doesn't give you the right to do it. And what a layoff is, and this is the way the law has always been interpreted, is that a layoff would be a constructive dismissal. And a constructive dismissal is a fundamental change to a substantial term of the employment agreement. So in normal times, so to speak, if you were to drastically cut someone's pay or change their role to demote them or something like that, or move them from Vancouver to Ottawa, that could be a constructive dismissal. But if you look at a layoff, think about the very fundamental basis of the employment relationship. It's that the employee will work and the employer will pay them wages for that work. If the employer all of a sudden comes along and says, you know what, for the next few weeks, you're not going to work and we're not going to pay you, that's a substantial change to a fundamental term. So how do all of these companies read about do it? If you're unionized, you have a collective agreement, and almost inevitably that collective agreement has a temporary layoff clause, which gives the company the right to impose them. A lot of larger companies also have temporary layoff provisions in their contracts. And this is one area where we get to say, I told you so. If you've worked with our firm for any period of time and you've asked us to help you with your contracts, we always recommend putting in a temporary layoff provision. And I will tell you, Hilda, that 9 times out of 10, our clients say, we don't do that. We don't lay people off.
Yeah.
And I will push back as much as I can and say, just in case. And no one ever imagined this scenario. But we've had numbers of clients who come back and said, we're so happy that we now have the option. Not that they have to use it, but they have the option. If you
I would
don't,
say
oh, sorry,
probably
go ahead.
less than 10% of the people put that provision in. So I will ask a question right now is what would you recommend people do to going forward? Because we know in Ontario, you can't do what we're doing without that layoff provision. What would you suggest people do? Um,
Yeah. Well, I'll make one more point because I know there has been some debate amongst my colleagues in the employment law bar, and some people have said that you can't look at the law as it existed before and apply the current situation or apply it to the current situation. And that may be true, and we may get a judge at some point who will say, you know what, in light of all the circumstances, the employer should not be penalized, but that hasn't happened yet. So basically, as an employer, and that's what we're telling our clients, you could go ahead with a layoff and you're taking your chances and you might win, but you might not. So to your question, what do you do in the short term is that if you don't have that temporary layoff clause, but you want to lay people off, go to them and ask them for their agreement. And we've had a lot of clients do that very successfully. If you're open and upfront and you make it clear that everyone is going to sacrifice, most times employees will be willing to agree, at least on a temporary basis. And then ideally long term, you're going to put new contracts in place, which will have that clause, which very clearly says we have the right to lay you off on a temporary basis in accordance with the employment standards legislation. So, and you're more on the people side, so you'll understand that.
of course.
It's all going to be a give and take, but that's going to be your ideal situation.
And I think it's important, there is this legal thing. All of us who have laid off people, it's against the employment standards law. So we have broken that. But having said that, given the circumstances, we really need to think about how you do it. So I think those companies that really spend the time to connect with their staff, you have this, we're in it together, what should we be doing? They're the ones that will survive and people will understand. But those that do it in a way that distance the staff, makes them feel unwanted and unvalued, they're the ones that are more likely to say, they screwed me. So I need to fight for what's right for me, what's right for my family, so I'm going to do this. So I think to balance that, the fact that we don't have it, we're at risk, do think about how you maintain positive working relationships with your employees.
Yeah, I think that's a great point. It always comes down to communication. And I always say, there's legal and the practical. I know you're very much in tune with the practical, which is so important because you're right. I mean, at the end of the day, things are going to get back to normal or at least close to what was normal before at some point. And you're going to want to have your workers come back and you're not going to want them to feel as though you took advantage of them. So it's got to be a dialogue.
Okay, I'm going to keep us moving so that we make sure we cover all these questions that we thought we would want to share. Reducing hours and wages, what kind of implications do you feel that people should be aware of from a legal perspective?
Yeah, this will be a shorter one because really the principle is the same, right? I mean, it's a constructive dismissal if it's a substantial change to a fundamental term of the relationship. So changing someone's hours, changing someone's pay, those are fundamental terms of the relationship. The only question here is it substantial? So for example, if I heard of one company that was going to cut out the RSP matching program, which would typically be sort of 4%. Is 4% going to be substantial enough to be a constructive dismissal? Probably not. So your risk is a lot lower if you do that, or if you reduce someone's hours by 5%, your risk again is lower. So it's the same analysis, but it takes you to a different conclusion in most cases, unless you're talking about more significant changes like cutting someone's hours by 30, 40, 50, 70%. Although the nice thing there is we do have the work sharing plan, which allows you to, as long as you apply for it, it's got to be formally done. Then the employee can get employment insurance benefits that will help to make up some of the loss if they qualify otherwise.
Yeah, the interesting thing about the work share plan is it has always been around for a long time, and people could take advantage of it. So in its prior to COVID-19 state, you had to apply, and the employee applies as part of the package, so they have to agree to it, and you had to have a 30-day period from the signing of the contract to the start of it. They've since reduced that down to, I believe, 10 days now, and the recovery plan that was part of the application is now just 1 to 2 sentences rather than a full-blown recovery plan, which made it onerous to even think about how to apply for that. So thank goodness, but it took them like two and a half weeks, because it wasn't there last week, but there is this provision now. So
No.
things are happening, and like wait and see is certainly the order of the day.
Yeah, and you don't have to wait too long in most cases. But you're right, that was a big question. I actually I tweeted to the federal government about probably 2 weeks ago now to say, what about the waiting period? And they never responded, but I'll forgive them for that. I'm sure they get a lot of tweets. But they finally acted, because waiting 30 days in the current environment, it's not feasible.
I'd be interested in your perspective on the wage subsidy program, which again just got the announcement today that it's 75%, and then there's a 10%. But today they just reduced the revenue loss, instead of 30%, 15% for March, because it's half of the month when it started, and then resuming 30% for April and May. Interested in your perspective to share with this group.
Yeah, I think the 75% wage subsidy is a great move. And I think, it was, I think, initially they said 10%, and that was very early days. And I don't think they really understood the implications of the situation at that point. And once they started to realize that there were going to be massive amounts of layoffs, we're already starting to see them, they acted. And I give the government credit. I mean, all levels of government have really been doing whatever they can to try to address the situation. But to me, the wage subsidy, if it's implemented well, and that's a big if, but if it is, that's a game changer. Because like you were saying before we started, Hilda, 2 weeks ago, a week and a half ago, everyone was talking about layoffs. Now I know a lot of our clients have been saying, well, you know what, if I can get 75% of the wages paid by the government, then I'm not going to lay my staff off, or at least I'm not going to lay most of them off. So they're going to avoid that, and that will help them avoid the employment insurance applications as well. So if it's implemented well, it will make a huge difference. And you touched on an important point, which is the 30% drop in revenue. A lot of employers were concerned they wouldn't be able to demonstrate that, as well as the fact that they've announced that the comparisons didn't always work. If you're comparing to March of last year, well, maybe we've had a great year up till now, so we're actually going to look good. So they are trying to make it as flexible as they can. I think the key now is, I know they were saying mid-May before the money starts to flow. I know everyone is really keen to have that come sooner, and a lot of businesses are really struggling. And I have tremendous sympathy for the businesses who are being told, on the one hand, you have to shut down, or they've had dramatically reduced revenues. Then they've got people like myself saying a layoff's going to be risky, but they've got a wage subsidy that's somewhere down the road, but they're not sure where. So I'm curious if you're seeing the same thing I am, that a lot of employers, though, are very, very keen on this program.
I think it's very interesting, because I think people have to digest what this means. And of course, the news keeps evolving and changing, right? So I was talking to a client one day, and we talked about the subsidy. Well, that's not going to help us. Where are we going to find the 25%? And a week and a half later, they sat back, they reflected where the cash flow is, what's going to happen. And suddenly the 75% is a godsend. It's great. We can do this. But 2 weeks ago, they said, so where are we going to get the 25% to cover that? So it's interesting when we hear something that's new for the first time, but when we had a chance to digest it and take a look at the big picture. So the difficulty with COVID-19 is that this is transformational change that is forced upon people, whether they wanted to do it. And every day it's something new, and people are adapting, not just for their business, but for their families, for them as individuals. So we are in such a state, but I think people, we're 3 weeks into this now, and people now are kind of evolving from deal with the emergency, what do I need to do? But now they're thinking, so what happens down the line? And people are saying, it sucks, but we'll deal through this. We'll get through this. And I think the government's message is, I think, very indicative of being very supportive. Mm-hmm. Safety first, family. We want you to focus on your family and keep them safe. And we will do our best to help you financially, so that's not another burden that you have to think about. So You know, I appreciate how the governments have stepped up to the plate in many ways. Many ways.
Yeah, no, I think they really have. And it's, look, nobody anticipated this. So they've had to react pretty quickly. And I think they've done a pretty good job. I just want to clarify, just I hope nobody's confused. You mentioned the 25%. I know that the government has said that they expect employers to try to do their best, to make best efforts to pay that. They haven't really gone further and explained what that means or how strict they'll be, but I know a lot of businesses have just said, look, we can't afford to. You know, the 75% is great and it will allow us to avoid laying people off, but we can't pay anything above that. And so far the government hasn't said, well, then we're not going to pay you the money. So that remains to be seen, but you shouldn't assume you have to pay it.
Yeah, I kind of, soft reading, because again, the details go, the assumption is that they will pick up the 25%. And do they pick up the 25% to the maximum, or are they expected to pay the full balance? So these are questions that certainly need to be asked. I want to shift now over to safety and the work environment. And maybe we could start generally talking about safety with regards to COVID-19 and your perspective from a legal point of view, what's happening there.
Yeah, and I'll be curious to hear about your experiences as well. But I mean, it's been interesting because, of course, we've got the list of essential businesses, and so a lot of businesses are running, and of course, a lot of other businesses are running remotely. I mean, our firm we're all working from home by way of example, but you do have a lot of businesses that people can't work from home. So it's retail or it's a service where they have to be physically present, and of course, employers have always had a duty to maintain a safe work environment. But now the way you assess that is very different. How do you assess that in the world of COVID-19? And I mean, the principles that the government has been telling us really are the starting points. So, self-isolation is ideal. If your employees can work from home, they should work from home. That's got to be number one. If it's at all possible, I don't want to hear employers saying, oh, we have to be in the office. If it can be done from home, it should be done from home. If it can't, then social distancing, which means keeping your employees as much as possible away from either their colleagues or customers and clients. So if you go into a grocery store, of course, you'll see that they only allow a certain number of customers at a time. And it's only one out of every 2 or 3 lines that are open. And they've often got either tape on the floor, or even I've seen physical barriers to divide the lines. And you have to keep sort of a shopping cart apart among the clients or customers. So you've got to do all that, and they should be doing wiping down all of the surfaces and providing soap and providing hand sanitizer. All the things that you would think of, just to keep anyone safe, employers should be doing. It's not up to the employees to do it. We're also encouraging our corporate clients to make sure that their health and safety committees are actively involved and putting together processes and putting together a reporting mechanism too, so that if someone is concerned about their safety, or if they're just unsure, that they know where to go and who to ask, and have a process made to deal with those situations. And then look at equipment as well. So providing masks, providing gloves, doing whatever you can to basically provide a safe work environment. That's the obligation. And I want to talk about the right to refuse unsafe work. Before I do, sure. I do want to kind of get your input and hear what you're seeing on that front.
I think, I too am concerned about the workers out there from a safety perspective who may choose to refuse to work. I'm a former IC nurse. I started my career in that. So I understand when they say, the mask, to share 2 masks in one shift, that's really, really tough. And to expect people to feel safe, I'm surprised there aren't more work refusals by even other people. But I think some people are doing it from a noble point of view, and they'll do what they can to protect themselves. But I'm not sure that the mask being worn only like twice a shift is enough. So I do have some concerns that way. What I'm seeing is people are just becoming more and more protective. When I was walking around the street, people used to say hi in the first few weeks or at the stores, and now people aren't even talking to each other because I think they're afraid to social distancing is really social distancing, and I personally like to thank the workers that are out there. So I think we should all do our part, but I think it's hard because I think that's another thing that business owners need to do, and I really appreciate some of the strategies that I'm seeing there to really ensure it happening.
Yeah, and I think a great point you make about all the people that we should really appreciate the job that they're doing out there right now. And a lot of businesses are being very creative and trying to find ways that, you know, to get work done, but also make sure to keep their employees safe, which I think is critical. But are you getting a lot of questions from your clients about, you know, what do we do if somebody just says they can't come to work?
I haven't received any of that, but I do, you know, if they've sort of, I'm getting them to start thinking about that, because it is possible that people can do that. Some people might even do that from a mental health point of view. This social isolation is causing a lot of stress for people, so they may not even be coming to work from a health issue point of view versus, and you can't kind of tell people that, okay, fine, you don't come to work, you're fired, because under safety legislation, people have the right to refuse work, and this can be considered unsafe work. And people and business owners need to take it seriously. They really need to take it seriously. And I like your ideas that, you know, you only have to check from an occupational health and safety perspective once a month, you know, in a cyclical fashion, but people need to be on top of it and heighten that awareness, heighten the training, and even the inspection. I think it needs to be stepped up in times like this.
Oh, for sure. And it's, you know, it's interesting you're talking about, you know, people refusing to come to work. I mean, so what we've been telling both sides, you know, employers and employees is, you know, if there is a legitimate reason, you know, for example, Ontario has enacted new leave. So if you are self-isolating because you traveled or came in contact with someone who had symptoms, then there's a protected leave. If you have to stay home to look after a family member, there's a protected leave.
Right.
So you can't, as you said, you can't fire somebody for that. They're entitled to be home. It's not paid, but it's a job protected leave. You've also got to be mindful of human rights concerns, and you can't fire someone because they have COVID-19 symptoms or anything to do with a human rights ground. But, you know, if push comes to shove, and hopefully it's not going to come to this, if someone is simply saying, look, I'm just scared generally, so I'm not going to come to work, they don't have the right. That's not a legitimate basis to refuse to come to work. And you can treat it as a work refusal. If they say there's something unsafe in the workplace, then you can, you know, get your committee involved. You may have to call administrative labor inspector, and they'll make a decision. But at the end of the day, someone saying, I'm just scared about the virus, I'm not going to come into work, is not a legitimate excuse. And I've had a lot of employer clients say, well, yes, but I need to cut my payroll anyway. So if they want to stay home and not be paid, then I'm happy with that. And that's great. But if you need the person there and they refuse, then you may have to go down that discipline road and ultimately treat it as a work refusal as you would any other time.
And I would just sort of kind of share with the participants, don't just assume that this person's making a refusal. There are people who have been traumatized, who have mental health issues, and perhaps something in that work environment is triggering them. And if they do have a mental health issue, you have a duty to accommodate. So you don't make the assumption that they're just refusing and you have the right to, you know, tell them to come to work or they're being dismissed. So do investigate, do always, when you talk to people, start from a neutral point of view. So what's up? I know you're saying you don't come to work, you're afraid. Can you tell me more? And then you start the dialogue. And as you investigate, you determine whether this is, you know, it should be something that you can dismiss something, or this is something that you have a duty to accommodate. So just that cautionary tale, because if that gets investigated and you did that, then that opens another set of concerns.
It does, and I love your point. I mean, and it's kind of like we said a minute ago, right? It all comes down to communication. So don't assume anything. But if someone says, I'm not coming to work, then instead of coming in and threatening, like you said, engage them in a dialogue, find out why, find out if you have a legal obligation to allow them to stay home or to accommodate. And if not, then you can assess your rights. But yeah, I think your point probably applies to everything we're saying, which is don't make any assumptions.
It's the key to all of this is creating good communications, whether it's by email, one-on-one, however you communicate, and building the trusting relationship so that when you're having that dialogue, it's an open, honest relationship, and you get to the problem rather than anybody making assumptions one way or the other.
Yeah.
I'm going to shift us to the future now. And when employees return to work, whatever time period that's going to be, do you see businesses having to bring people back when this is all over, or will they be able to selectively do it? And therefore, what are some of those risks then if we're bringing back some people and not others?
Yeah, I've started to get that question more and more.
I know, because we're into it 3 weeks, we're adjusting now, and now we're thinking more into the future.
Yeah, it's very true. And look, and the unionized environment, of course, is very different. So if you are governed by a collective agreement and you've laid people off, they're going to be recall rights, they're going to be governed by seniority, and that's very different. Assuming there's no collective agreement, then you can pick and choose whoever you bring back or don't bring back. The only limit would be human rights. So you can't pick all the men or only pick people of a certain race or background or sexual orientation or things like that. But it's assuming that none of those factors are in any way related to your decision-making process, you can pick and choose whoever you want in whatever order you want, bearing in mind, of course, that if you allow someone to stay on a temporary layoff beyond the time of its set out in legislation, that will trigger a termination. And when you trigger a termination, you're on the hook for all of the severance obligations, which, and we don't have time to go into this in any detail, but it's not just the employment standards legislation. It could also be common law, which can be months, if not years of severance. So you got to be mindful of that. But I've had clients who've said, look, we had a few people that we really didn't want to keep around anyways. So now this is just kind of accelerating the process.
I know there was a person who commented that in the newspaper and saying that some people are saying that they're using this as an excuse for when people come back, only bring back the ones you want to bring back, and just say we don't have room for you. So I think that's a very interesting point.
Yeah, and look, I've seen it from the individual side as well. I've had a few individuals who've come into our office, well, not come into our office, but virtually come into our office. And what they've said is, look, I got the notice of layoff and I'm okay with that. I don't mind being laid off, but I just suspect that they're not going to bring me back. And it's interesting because, and you know this, I'm sure better than I do. Usually when people are going to be like, oh, they often know. Yeah, they often know what's going to happen. So, when people say this to me, I said, well, don't discount your gut feeling, because you're probably right. But at the end of the day, what I've said to them is, look, they don't have to bring you back. What they have to do is give you whatever severance you're entitled to. So if it happens, we'll talk about that.
There's probably a number of people here who are small business owners, and employment standards says that if you're less than 50, severance is not required by employment standards. Are you suggesting, though, that for people who've got people say have worked 10 or 20 years, that there should be some severance from a common law perspective? Your thoughts on that?
So I think we need to be very clear. I know this gets very confusing. So there's severance pay under the Employment Standards Act, and that will also apply if your payroll is more than $2.5 million. So regardless of the size of the company. But what I was referring to is common law, reasonable notice. So unless you have a really good contract, which says the employee does not get notice under common law, you have to give that to them. Doesn't matter how big you are, what your payroll is. And that can be months, and like I said, even years. And that's going to be the bigger concern here. Is you got someone who's been with you for 5 years, 10 years, and you don't bring them back. You don't have to, but you will have to pay them severance. And I'm talking about common law severance.
So you're saying we should be thinking common law severance for those, because they could argue, a person could come back and argue that you don't owe me under employment standards, but you definitely owe me under common law. Okay.
Exactly, and that's the bigger risk unless you've got a contract. And again, if any client we work with, their contracts will specify what the severance amount will be. But if that's not in your contract, then common law will apply, and it can be pretty expensive.
Cool. So I think that kind of gives the participants an idea of some of the things that Stuart and I thought we should at least share for the group, but we're at 30 minutes now, and I want to open this up to give people 15 minutes to ask questions. We would stay on the line maybe an additional 5 or 10 minutes if there are more questions, if that's okay with you, Stuart.
Yeah, I may have to limit it to about 5, but I'll do what I can.
No worries, but we've given them 15 minutes. So do you want to start with the chat questions first, or if somebody is interested in actually having the dialogue, do put it in the chat, and Jenny will make sure that you you get their answers. So Jenny, do you want to share with us what the questions are?
Yeah, sure. So we have one from Kyle Lee. Sorry, this participant asked about what you say about like changes in various provinces with regards to temporary layoffs. So here, the participant had an example about Saskatoon where the threshold is 6 days and it's now 12 weeks. And then New Brunswick classifies COVID as an exception requirement, so employers no longer have to provide notice or pay in lieu of notice at termination. And then one more example the participant gave was in British Columbia, where COVID-19 is now an unpaid job protected leave, and should employers work with eligible employees to use such leave before moving on to temporary layoff?
Yeah, so how do you keep on top of this? I mean, it's almost impossible for any of us. And I know my team is doing whatever we can. And like I mentioned at the beginning, we have a running blog. We try to post updates. But realistically, whatever province you're in, I would be constantly checking their website, checking the news feeds, because these things are changing on a regular basis. And at the end of the day, and I know, again, it sounds self-serving, if something happens to you, I would go see an employment lawyer. And you know, the worst thing you can do, and I'll come back to what I said a few minutes ago about common law notice. So let's assume that you are let go and you're told that you're going to get your Employment Standards Act notice, and that's 3 or 4 weeks. But at common law, you could be entitled to 4 or 5, 6 months. And if you just walk away, you're leaving a whole lot of money on the table at a time when you've just lost your job. So as I said, to keep on top of it, check the websites of whatever province you're in. But if anything happens and you're not sure of your rights, that's when you need to get proper advice.
So my feeling on this is that you have to get the facts. And because each province is changing what they are, I, like Stuart, recommend that. There are different websites that you can go to. I know the Canadian Federation of Independent Business Owners, CFIB, has a great website. And what they do is they identify them in sections, and then you pop it up. So if you want to look about EI, pop that. If you want to look about the CERB, you pop that. And they're trying to keep it current, and they're actually giving you the Canadian government website where it's that. For the provinces, again, go to your direct province website to get the information on how to apply, what does it mean, because the good example is like the 75% wage subsidy. This today is the 4th iteration of a wage subsidy. So you snooze, you lose kind of thing. You do have to stay on top, and you have to get your facts, and the fact is sourced at the government level. So I think in the first week, I was trying to stay abreast of everything and say, yes, there's an emergency declaration in these provinces. And now there's just way too much information. And I encourage people to get the facts from the sources, or find websites that are giving good sources for you. So great question. Next question, Jenny.
Yeah, so from Janet Burke, how do we as employers claim wage subsidy or EI for self-employed? And what about the bank program for $40,000?
I'll jump in first, Hilda, if you want to jump in after. So there's a couple of things here. So the wage subsidy, we're still actually waiting for all the details as to when the portal is going to be open. There is going to be a portal. It's going to be through CRA, but it's not open yet. And that's something the employer will apply for. And the money, if it's dispersed, will be dispersed to the employer. So very different than EI. If for EI, of course, it's an employee that applies. They have to have a record of employment to be eligible. So if you're an employer and you're laying somebody off, or if you're going to be part of the wage subsidy program, you've got to give them a record of employment. But Jeanette also mentioned self-employed, and this is coming up a lot. And this is a big concern for a lot of our clients who are, they have small businesses, they're self-employed. If you're self-employed, you don't get employment insurance because it's not employment, you're in a business. And the CERB is going to be your friend in this case, because the CERB is designed to help those who don't otherwise qualify for EI, either because they're self-employed or they don't have enough insurable hours, or for whatever reason they don't get EI. So the CERB will give you $2,000 a month. And I was just saying to Hilda before we started, it's changed also this morning. So again.
Oh, did it? I didn't catch that one.
You got to stay on top of all this, because the biggest criticism up until about 4 hours ago was that if you had any, or phrase another way, to get the CERB, you could not have any income for a 14-day period. They've now realized that's a little too restrictive. So the changes, I just want to check my notes here. Yeah, as long as you earn less than $500 in a month and work less than 10 hours in a week, then you will still be able to qualify. So it's been loosened a bit, but as Hilda was saying before, it may change again tomorrow or next week. So you got to stay on top of it.
I know that some people have applied for the CERB, so it's CERB, and you go to the government's website. What they are recommending that you apply by birth month. So if it's January, February, March, it's Monday. Then April, May, June, Tuesday. So once you get to Thursday and we finished all 12 months, Friday, Saturday, and Sunday, anybody can apply at any time. And then it recycles again. January, February, March is Monday. So that's how you do it. And then about the program for $40,000, I would recommend any business owners to go and look up what that means. But essentially, it is through the bank. You call your bank, and it is a loan, or I've heard of it as a line of credit as well. So if you work with them, it will be interest-free for 2 years. If you pay it by the end of the 2 years, like there is no interest that you've paid it off, it will be 10%, 10,000 of it will be forgivable. So to me, it's a pretty good deal. It's a no-brainer. You have that discussion with them. If you're eligible, you're eligible. If you're not, then you're not. But again, go to the bank, because it's supposedly in place now and you can make that phone call. Had some people have already started doing that. So go to your friendly bank person, because banks are usually very conservative, but the government has written off the risk for them. So they're really just using their engine, their processes, although they had to tweak them, to provide this for you. So great question.
That's a great point. And I was just going to say on the, sorry, I totally lost my train of thought there. Yeah, it'll come back to me. We'll move on.
Okay. Another question from Feldma is, what do you mean by common law and how is that calculated?
Yeah, so this could be an hour-long discussion, but I'll try to make it a very short one. So what everyone needs to understand, and again, getting back to common myths and misconceptions, these are things people don't usually understand. If you let somebody go without cause, in other words, if they haven't done anything enough to warrant being fired, then you can let them go at any time for any reason, but you've got to give them notice or severance. And the question is, how much do they get? So your employment standards legislation will set out the absolute minimum they can get. And it's typically about a week per year of service with some variations between the provinces. But that's the absolute minimum. The common law, which is basically the judge-made law from the last many hundreds of years, has said that as a legal principle, everyone is entitled to reasonable notice of dismissal. And the common myth out there is a month per year. What our courts have said is we're not only going to look at the length of service, we're going to look at that for sure. But we're also going to look at the person's age. We're going to look at their position, the nature of their job. In other words, was it clerical? Was it managerial? Was it sales? We'll look at the availability of similar work, which I don't even know how you assess that in today's situation. And we're going to try to figure out how long it should take the person to find new work. So there is no easy calculation, but it can be extensive. The unofficial cap is 24 months, or in other words, 2 years. So this can be an extensive and expensive endeavor to go down. But like I was saying before, if you have a contract, you can basically displace that whole concept and just say, this is what you will get. Yeah. If you don't have that in your contract, you're on the hook for common law. And that's, to me, the biggest potential cost someone will face if you're going to let somebody go, and you need to be aware of it.
About a decade ago, when people wrote contracts, they did not put a termination clause in that said, if we terminate you, this is what you get, right? So that, but nowadays it's very, very standard. But we didn't embrace the temporary layoff notification. We did do the termination. So I will add to what I do, because I think because I was a company, and I was essentially the COO, I really worked closely with my employment lawyers to understand things. So when I support companies with my HR consulting, I look at a variety of perspectives, and you and I, we have similar things. My focus is on the people side. So I like to balance the risk legally with the needs and the long-term longevity of your work culture and your retention of people. That's my forte. Where I seek the advice of a human a resources lawyer is things just like common law, just like when you terminate, you want to make sure you got the language right. When you terminate somebody, you want to make sure the compensation is fair. So this is where I know for myself when I would use a lawyer, and when I would try to do as much as I can because of my HR expertise. I kind of think of myself as a chess player. When you're a novice and you're playing chess, you could lose in 3 moves, right? But because of the years of experience I like to think that I know the moves that you need to do so that you can stay in the game or have a stalemate at the end rather than so that's where my perspective comes from it, and Stuart's, and I value the human resources lawyers because you have the knowledge and you help mitigate the risk that we need so that we're not spending an arm and a leg to get what is needed. Next question.
So Jonathan Landon asks, how does all of this apply to part-time roles?
Yeah, that's a great question, Jonathan. Thank you. I mean, I'll give you the simple answer. It applies exactly as we said. Everything applies the same way. An employee is an employee is an employee, and so they can be full-time, part-time, fixed term, indefinite. Doesn't really matter. Obviously, the dollar and the hours will vary, but the principle of constructive dismissal, the principles regarding temporary layoffs, for wage reductions, they would all apply in the exact same way. It just might mean that when you implement it, the dollars are a little different. But they are employees, and that's different than a casual worker, just to be very clear. So I've got a few clients who have casual workers who basically they work when they're called. So if you don't call them, they don't work, they don't get paid. And your obligation to them is almost nothing, if not nothing. But a part-time employee, if they work regularly part-time, then you have obligations to them as well.
Any other questions?
Yeah, we have one last one, and if anyone wants to jump in for their last concerns, please feel free to do so. We have one from Victoria. Does the wage subsidy apply to businesses that are considered non-essential, that are forced to close down and have no option to work from home? She gave an example. My employee is asking me to rehire at the 75% wage subsidy rate versus the 55% EI rate, but won't physically be recalled to work.
Yes, I think we're both nodding our heads. Yeah, this is a perfect scenario for a business that is non-essential, that essentially has to close their doors. This is where the wage subsidy can be a lifesaver, essentially. And I mean, our firm, we work with a lot of dental practices, for example. And so, of course, the colleges have all told the dentists to either shut down or only do emergency work, basically. So most of our clients have either just closed their doors completely or they've got a skeleton staff. And most of them were just appalled when I said they're, on the one hand, they're being told to close, and on the other hand, I'm saying you still got to pay your workers. So the wage subsidy is a lifesaver for situations like that.
Yeah. I had a thought on it, but I just lost it, so it's okay.
I see why we're so alike.
It's a lot of thinking, and what's the question again? And all the pieces of the puzzle that have to go with it.
Yeah,
We'll
I know
take
what you mean.
one more question because I know Stuart has to go, and it's 3:48 right now. Is there any last-minute question?
Not on the chat. If anyone would want to unmute themselves and speak, feel free to do so.
We'll wait and see. I would like to thank Stuart for coming and joining us. I think it gave people a lively discussion of some of the nitty gritty that HR professionals, managers, and business owners are thinking. We will have a copy of the recording and we'll send that along with an email, which we do each time. I will be, if you want to send some information, Stuart, we'll certainly be happy to include that.
Sure.
reminder to people that I do offer a one-on-one free consultation if they want to do it. And I've started an HR on-call service for people by discounting it at 50% of my normal rate. And it'll be good for 6 weeks of 2 hours, for example, at $300. And we'll send that information later. Next week, we are going to be talking on financial survival, financial success. And Heather Purcell from Financially CPA is going to be joining me as my speaker. We are switching from Monday, Wednesday to Wednesday and Friday at 10 o'clock. I don't really want for Trudeau to be doing a speech and I don't know what he's saying. So it'll be Wednesday and Friday. And our Friday session will now be what I'll call Friday Open Forum. It'll be an opportunity for people to ask questions and to share some of their stories. So hopefully you'll join me. Stuart, thank you again. You are so helpful in helping share your knowledge and wisdom to others. Any last words, Stuart, before you go?
Yeah, well, first of all, thank you again. I really enjoyed it. And I guess last words, I will send you, Hilda, we just updated our FAQ. It's now the third iteration of our COVID-19 FAQ. So please remind me, I'll send that to you because I think it'd be great to send it around to everyone.
Yeah.
Please keep up to date on our running blog, and I'll just repeat the invitation. Please feel free to reach out to us. If we can help you, that's great. If we can't, there's no harm done, but I really want to avoid people making decisions without understanding the legal implications. So please, feel free to reach out before you make a decision. And Hilda, thanks again. I guess, depending on where things go, maybe we'll do this again in a few weeks.
You never know, right? Because there's so much. And I will keep doing this bi-weekly until people are safely on the other side of what we're going through. So thank you again, really appreciate it. And I know my audience appreciated having you here.
Thanks again, have a great day and stay safe, everyone.
Yeah, and have a good Easter and Passover, time with families in a virtual way or whatever way you share. Take it easy.
A socially distant way, yes.
Yes, stay safe, everybody. Bye.